"You're telling this court," the judge said slowly, "that this entire legal team is here? For one employee?" The lead corporate attorney didn't flinch. "We take all allegations seriously, Your Honor." Across the room, a single woman sat beside one attorney. No assistants, no stacks of binders, no entourage, just a folder and steady hands. Her name was Elena Brooks. The judge looked at her briefly. "And you stand by your claim?" Elena's voice was calm, but tight. "Yes, Your Honor." The corporate attorney smiled faintly. "For clarity," he said smoothly, "our client denies all allegations." Behind him sat 11 additional attorneys in identical dark suits. Asterisk. The imbalance was visual. Deliberate. The judge leaned back. 12 attorneys. "Complex corporate structure," the lead lawyer replied. Elena's attorney rose. "Or intimidation." A murmur moved through the gallery. The judge raised a hand. "Order." He turned to Elena. "You understand the burden of proof rests with you, lass." "You, lass," repeated misconduct from your direct supervisor. "Yes." Asterisk and retaliation after reporting it. "Yes." The lead corporate attorney stepped forward. "Your Honor, this is a disgruntled employee upset about a denied promotion." Elena didn't look at him. She kept her eyes on the judge. "I reported what happened," she said. The lawyer smiled again. 3 months after, performance warnings began. Her attorney objected. "Mischaracterization. Sustained," the judge said. The corporate lawyer adjusted his tone. "Our records showed declining metrics prior to any complaint." Elena spoke quietly. "I have copies of the internal emails." Asterisk. The lead attorney raised an eyebrow. "Emails can be interpreted in many ways." The judge looked at Elena's counsel. "What evidence do you intend to present?" Her attorney opened a thin folder. "Your Honor, we will present documentation of internal complaints, HR responses, and a recorded meeting." The courtroom shifted. The corporate legal team didn't react visibly. But one junior associate leaned slightly toward another. The judge noticed. "A recording?" "Yes." The lead corporate attorney's tone remained calm. "Your Honor, we object to any recording not previously disclosed." "It was disclosed," Elena's attorney replied. "Filed under supplemental evidence yesterday." The corporate lawyer glanced behind him briefly. Asterisk. Then back at the bench. "We reserve objection pending authenticity." The judge nodded. "That will be addressed." He looked at Elena. Double quotes, "Ms. Brooks, did you attempt resolution internally?" "Yes." "And what was the response?" Elena inhaled slowly. "They said I misunderstood tone." A faint ripple moved through the room. The corporate lawyer interjected. "Your Honor, tone is subjective." The judge held up a hand. "You will have opportunity." He turned back to Elena. Asterisk. Did anyone witness the alleged incidents? "Yes." "Will they testify?" "Her attorney answered. "One is scheduled." The corporate lawyer smiled slightly. "Former employee." "Yes." "Terminated for unrelated reasons," Elena's attorney replied. The judge leaned forward slightly. "This court will not be distracted by employment histories unless directly relevant." The room steadied again. The lead corporate attorney stepped closer. "Your Honor, this case attempts to transform workplace friction into litigation leverage." Asterisk. Elena finally looked at him. "It wasn't friction." The judge noticed the shift. "Ms. Brooks, you may respond." "It was patent," she said. Silence. The judge watched her carefully. "Define patent," Elena's hands tightened slightly. On the table, comments in private meetings, late-night messages, suggesting my advancement depended on being agreeable. The courtroom went still. The corporate attorney remained composed. Ambiguous phrasing. Elena's attorney spoke firmly. It escalated after refusal. The judge's eyes narrowed slightly. To retaliation. Yes, the corporate attorney stepped forward again. Performance reviews documented missed targets. Elena's attorney responded immediately. Targets changed after complaint. The judge looked at both sides. This court will examine timeline carefully. He turned to the clerk. Mark timeline exhibit. The clerk nodded. The judge then looked at the row of 12 corporate attorneys. Why, 12? The lead attorney answered smoothly. Corporate protocol? The judge's voice cooled slightly. Or deterrence? No answer. Elena swallowed. The imbalance was visible to everyone. One employee, one lawyer, versus 12. The judge leaned back again. Proceed with preliminary testimony. Elena stood. Her voice trembled for half a second, then steadied. I joined the company 4 years ago. She spoke clearly. I was promoted twice. The corporate lawyer nodded faintly, as if acknowledging success. 3 months before my third review, my supervisor began asking to meet off-site. The room tightened. The corporate attorney's face remained neutral. I declined. And? The judge asked. He said I wasn't being a team player. The corporate lawyer scribbled. Something. Elena continued. After I declined again, my evaluation dropped. The corporate attorney stood. Coincidental timing. Elena looked directly at the judge. I filed a complaint. The judge nodded. And the response? HR said they would monitor the situation. Did it improve? No. The corporate attorney approached. Ms. Brooks, you received written feedback about missed deadlines, correct? Yes. Before filing your complaint? Yes. And you admit those deadlines were missed? Yes. The courtroom shifted slightly. The attorney pressed. So performance concerns were legitimate. Lena's attorney objected. Context. Matters overruled? She may answer. Elena took a breath. I missed 2 deadlines. The corporate lawyer nodded. Double quotes, thank you. But, she added firmly, those projects were reassigned without notice. The lawyer paused. By whom? My supervisor? The tension sharpened again. The judge leaned forward. This court will require internal reassignment logs. The corporate lawyer hesitated. We can provide summaries. No, the judge said evenly. Logs. The word hung heavy. Elena sat down slowly. The imbalance remained. But something had shifted. The judge wasn't rushing. He wasn't dismissing. He was watching carefully. The corporate legal team whispered among themselves. The judge noticed. Counsel maintained decorum. Silence returned. The judge looked at Elena once more. Ms. Brooks, do you stand by every statement made today? Yes. No hesitation now. The judge turned to the corporate attorney. And you deny every allegation? Categorically. The judge nodded once. Very well. He glanced toward the evidence table. We will begin reviewing submitted materials. He paused. And the recording. That word changed the room again. The corporate attorney's composure tightened. Slightly, but only slightly. The judge's voice lowered. If authentic, This court will consider its weight carefully. Elena's attorney nodded. It will speak. Clearly, the judge looked between them. Asterisk, this matter is far from decided. He tapped the file lightly. But this court does not measure justice by the number of attorneys seated at one table. The gallery felt that the imbalance no longer looked invincible. It looked strategic, and strategies can unravel. The judge lifted the first exhibit. Proceed. Asterisk, the judge adjusted his glasses slightly. Counsel, he said, looking at Elena's. Attorney, you may introduce the recording. The courtroom grew still in a way that felt heavier than silence. Even the 12 corporate attorneys stopped whispering. Elena's attorney stood. Your Honor. Exhibit 14 is an audio recording of a meeting between Ms. Brooks and her direct supervisor, Mr. Randall Pierce. The meeting occurred in his office during standard business hours. The lead corporate attorney rose immediately. Objection to characterization. We have not stipulated authenticity. The judge nodded. Foundation first. Elena's attorney turned toward her. Ms. Brooks, did you personally record this meeting? Yes. Why? Elena swallowed. Asterisk, because the previous meeting wasn't documented properly. A ripple of tension. The corporate attorney stepped forward. So you secretly recorded your supervisor? Yes. You did not inform him? No. The attorney turned to the judge. Your Honor, this demonstrates premeditated hostility. Elena's attorney responded calmly. It demonstrates fear. The judge raised a hand. This court will determine relevance. He looked back at Elena. Was the recording altered? No. Asterisk, has it been edited? No. The corporate attorney interjected. We require forensic verification. You will have it, the judge replied. He turned to the clerk. Play. The recording. The room felt compressed. A faint click. Static. Then voices. A male voice. Calm. Controlled. Sit down, Elena. A slight shuffle sound. Then Elena's recorded voice. You wanted to discuss my review? Asterisk, yes. A pause. Your numbers are fine. A slight shift in the courtroom. The corporate legal team didn't move. The recording continued. But advancement isn't just about numbers. The judge leaned forward slightly. What does that mean? Elena's recorded voice asked. It means alignment. A faint murmur. The prosecutor glanced toward the defense table. The recording continued. Alignment with what? With leadership? Expectations. And what are those? Asterisk, a small chuckle in the audio. Don't make me spell it out. The courtroom tightened. The corporate attorney stood. Your Honor, this is vague. Sit, the judge said without looking at him. The audio resumed. You've been distant lately. The supervisor's voice said. I've been working. That's not what I mean. Silence in the recording. Then, I'm married, Elena's. Recorded voice said. The courtroom froze. The supervisor responded smoothly. That's not relevant to growth. A slight scrape of chair. You're misreading this. He added. The judge's expression hardened. The recording continued. I'm not comfortable with these conversations, Elena's voice said. Comfort is part of partnership. The audio? Clicked off. Silence filled the courtroom. It wasn't dramatic. It wasn't explosive. It was subtle, calculated, which made it worse. The judge looked up slowly. Is that the complete recording? Asterisk, yes, Your Honor, Elena's attorney replied. The corporate attorney stood. Your Honor, the recording contains no explicit misconduct. The judge turned toward him. It contains implication. Implication is interpretation. The judge leaned forward. An interpretation is for the court. The corporate attorney shifted strategy. Even if tone is questionable, it does not establish retaliation. Elena's attorney stepped forward. Then allow us to move to the timeline. The judge nodded. Proceed. A screen displayed internal. Company emails. Elena's attorney highlighted dates. Asterisk recording occurred March 3rd. Click. Performance downgrade issued March 10th. Click. Complaint filed March 12th. Click. Project reassignment March 15th. The courtroom felt the pattern tightening. The corporate attorney responded quickly. Correlation does not prove causation. The judge looked at him. No, but it suggests proximity. Elena's attorney continued. On March 20th, Ms. Brooks. Key accounts are transferred. The judge raised a brow. To whom? Asterisk to a newly hired associate reporting directly to Mr. Pierce. The lead attorney spoke again. Business restructuring. The judge's voice cooled. Produce restructuring. Plan documentation. The corporate attorney hesitated half a second. We will submit summary. Documentation. The judge repeated. The word echoed again like before. Logs now. Documentation. The pattern was familiar. The corporate wall of confidence began to thin. Elena sat silently, watching the 12 attorneys consult one another. The judge looked at her. You filed complaint internally? Asterisk, yes. And what was the result? HR closed it in 2 weeks. Reason? Insufficient evidence. The judge nodded slowly. And were you interviewed thoroughly? No, the corporate attorney objected. Speculation. Overruled. Elena's attorney added. We request HR's internal investigation notes. The corporate lawyer exhaled. That includes privileged material. Asterisk submit for in-camera review. The judge said immediately. The courtroom shifted again. The judge was not dismissing this. He was digging. The corporate attorney adjusted his glasses. Your Honor, the company has anti-harassment training protocols and compliance certifications. The judge responded evenly. Training does not immunize behavior. A murmur ran through the gallery. The lead attorney tried another approach. Ms. Brooks recorded selectively. Elena's attorney stepped forward. We have additional text messages. The courtroom reacted audibly. The corporate team stiffened. The judge looked up. Asterisk. Text messages. Yes. He nodded once. Submit. Screens changed. Late night messages. Appeared still awake. You owe me that dinner? Don't be so formal. Advancement requires trust. The judge's face did not move, but the air did. The corporate attorney stepped forward quickly. These messages are ambiguous. Elena finally spoke again. They weren't ambiguous when my evaluation dropped. Asterisk silence. The judge leaned back. Slowly, he looked at the 12 attorneys. Then at Elena and her single counsel. This court does not operate on intimidation, he said calmly. The words landed heavily. The corporate attorney replied carefully. We are not intimidating. The judge's gaze sharpened. Then why 12? No answer this time. The judge turned to the clerk. Schedule continued hearing for witness testimony. The corporate attorney spoke up. Your Honor, we move to dismiss for failure to establish explicit misconduct. The judge did not hesitate. Asterisk denied. The room absorbed that. The judge continued. This court finds sufficient pattern evidence to proceed. Elena closed her eyes. Briefly, not in celebration, in relief. But the judge wasn't finished. He looked at the corporate table. Mr. Pierce will testify. The lead attorney stiffened. Your Honor, he will testify. The firmness in the judge's voice left no room. The corporate team began whispering urgently. Asterisk. The judge's gaze moved across them slowly. Bring him. The gavel struck lightly. Court recessed until witness is present. The room erupted in low conversation. Elena's attorney leaned toward her. You did well. She nodded. Her hands were still trembling. Across the room, the 12 attorneys were no longer sitting comfortably, because the recording had done something subtle, but powerful. It had made the imbalance visible, and when imbalance becomes visible in court, it becomes vulnerable. The doors at the side of the courtroom opened again. Tall man in a tailored suit entered. Asterisk confident, controlled Mr. Randall. Piercy took his seat at the witness stand. He did not look at Elena. The judge returned. Mr. Pierce, he said calmly, you understand you are under oath. Yes, Your Honor. The judge's eyes settled on him. Let's discuss alignment. Silence fell once more, and this time the tension was directed at the corporation. Asterisk. Let's discuss alignment. The judge repeated calmly. Mr. Randall Pierce adjusted his cuff slightly before answering. Alignment refers to collaborative integration within leadership expectations. The lead corporate attorney nodded faintly. Satisfied with the phrasing, the judge didn't react. Defined collaborative integration. Pierce offered a small, professional smile. Shared vision. Communication. Cultural fit. Elena's attorney rose slowly. May I proceed with cross, Your Honor? You may. She approached the witness stand without rushing. Mr. Pierce, you supervised Ms. Brooks for how long? Approximately 14 months. And during that time, prior to March, how were her performance evaluations? Asterisk generally acceptable. Acceptable, she repeated. Any written disciplinary actions? No. Any formal warnings? No. The courtroom was quiet enough to hear papers shift. Elena's attorney continued. In the audio recording played earlier, you stated her numbers were fine. Do you dispute that? Pierce hesitated slightly. No. Then why did her evaluation decline 1 week later? Pierce leaned forward. Performance metrics are dynamic. Dynamic, she repeated. Were her sales figures lower? They were consistent. So not lower. Asterisk, the corporate attorney stood. Objection. Counsel is testifying. Sustained. Rephrase. Elena's attorney nodded. Did her objective numbers decrease? No. Then what changed? Pierce maintained composure. Attitude. A faint ripple moved through the gallery. Elena's attorney tilted her head slightly. Define attitude. Professional engagement. The judge interjected. Be specific. Pierce paused. Asterisk, she became less responsive to leadership outreach. Leadership outreach? Elena's attorney asked. You mean late-night messages? The corporate attorney objected. Argumentative. Overruled, the judge said calmly. Answer? Pierce's jaw tightened slightly. I occasionally communicated after hours. How many times did you message her after 10 p.m.? I don't recall. More than 10. I don't recall. More than 20. Silence. I don't recall. The judge leaned forward slightly. Mr. Pierce, you are under oath. Asterisk, yes. Your Honor. Do you dispute sending the messages displayed earlier? No. Elena's attorney stepped closer. In one message, You wrote, advancement requires trust. What did you mean by that? Trust in leadership. And what specifically did Ms. Brooks need to do to demonstrate that trust? Be more collaborative? The courtroom felt the circular language tightening. Elena's attorney shifted after she declined your off-site meeting invitations. Did her workload change? No. She lifted a printed exhibit. Project reassignment log, March 5th, 10th. Are you familiar? Pierce glanced at it. Asterisk, yes. You reassigned 2 of her largest accounts. Yes. To whom? Associate Miller. Who reported to you? Yes. Was Associate Miller newly hired? Yes. With less experience? Yes. The tension in the room sharpened. The corporate attorney stood again. Business discretion, the judge replied without looking at him. This is cross-examination. Asterisk, he turned back to Pierce. Why reassign her highest value accounts? Strategic. Adjustment. The judge's tone cooled. Strategic to what objective? Team optimization. The judge didn't blink. Define optimization. Pierce hesitated. Improved collaboration. Elena's attorney spoke carefully. Did Ms. Brooks file a complaint before or after those reassignments? After. The attorney walked slowly back toward the evidence screen. March 3rd. Recording. March 10th. Evaluation drop. March 12th. Complaint. March 5th, 10th. Reassignment. She turned toward the judge. Asterisk, the sequence is documented. The corporate attorney stood quickly. Sequence does not prove motive. The judge nodded once. Correct. He looked at Pierce. But motive can be inferred from conduct. Silence. Elena's attorney continued. Mr. Pierce, after the complaint was filed, did you communicate with HR? Yes. Did you recommend any action? I provided performance context. Did you recommend termination? No. But within 6 weeks, Ms. Brooks was placed on performance probation. Asterisk, Pierce remained steady. Yes. Despite consistent numbers. Yes. The judge's gaze sharpened slightly. Pierce added quickly. Performance involves more than numbers. Elena's attorney stepped forward again. Did you ever explicitly tell Ms. Brooks that her promotion depended on attending dinners with you? No. Did you imply it? No. Did you suggest advancement required comfort? Pierce's face tightened. No. The judge spoke calmly. Asterisks, the recording suggests otherwise. Pierce inhaled slowly. Tone can be misinterpreted. The judge leaned forward. Intent can be disguised. The room was silent again. Elena sat still, hands folded tightly in her lap. The corporate team was no longer relaxed. They were calculating. The judge looked toward the corporate. Attorney, you may redirect. The lead attorney rose smoothly. Mr. Pierce, did you ever explicitly threaten Ms. Brooks' employment? No. Did you ever make direct, inappropriate proposals? No. Is it common for executives to mentor employees informally? Yes. And is career guidance sometimes misunderstood? Yes. The attorney turned toward the judge. The plaintiff is interpreting professional mentorship as misconduct. Asterisk, Elena's attorney objected. Characterization. Overruled. The witness may answer. Pierce nodded. Yes. The corporate attorney stepped back. No further questions. The judge leaned back slowly. He looked at Pierce, then at Elena, then at the timeline again. The imbalance that once felt overwhelming had shifted, not because the corporation lacked lawyers, but because repetition had revealed pattern. The judge folded his hands. "Mr. Pierce," he said calmly, "you are free to step down." Pierce left the stand without looking at Alina. The judge turned to both tables. "This court has reviewed the recording, message logs, timeline, and testimony." He paused. "The matter is not as simple as either side suggests." The room held its breath. The judge continued. "The defense argues ambiguity." He looked toward the corporate table. "The plaintiff argues Pata." He looked toward Alina. "This court will not rush judgment." A pause. "But it will examine intent." He glanced toward the clerk. "Schedule continuation for HR testimony and internal investigation records." The corporate attorney spoke carefully. "Your Honor, we request protective order on sensitive corporate documentation." The judge responded immediately. "Submit under seal for review." The lead attorney nodded. Alina exhaled slowly. This wasn't victory. Not yet, but it wasn't dismissal either. The judge leaned forward one final time. "Ms. Brooks," he said calmly, "this court recognizes the imbalance in representation." The 12 attorneys shifted subtly, but representation size does not determine outcome. He turned to the corporate table. "Nor does corporate structure shield conduct." Silence. "This hearing will continue." The gavel struck. Not final, not decisive, but deliberate. As the courtroom began to empty, Alina remained seated for a moment. Her attorney leaned toward her. "It's working." She nodded slightly. Across the room, the 12 attorneys were no longer whispering casually. They were reviewing damage, because the recording had opened the door, and once opened, intent is harder to close. The story is not over. Next hearing. HR testimony. Internal emails. And the question that still hangs in the air was this: mentorship or manipulation? Ms. Hale did not rush. She adjusted her glasses, glanced once at the plaintiff, then toward the defense table where 12 corporate attorneys suddenly looked far less certain than they had 3 days earlier. "Call your next witness," the judge said evenly. The defense attorney rose. "The defense calls Margaret Ellis, Director of Human Resources." A woman in her late 50s approached the stand. Controlled posture. Corporate composure. She took the oath. "Ms. Ellis," defense counsel began smoothly, "how long have you served as HR Director at Valiment Technologies?" 14 years. "And during that time, have you implemented policies regarding workplace conduct and harassment prevention?" "Yes. We have a strict zero-tolerance policy." "Did the plaintiff, Ms. Carter, ever file a formal harassment complaint prior to her termination?" "No, she did not." A murmur shifted through the courtroom. The defense lawyer paced slightly. "And in your experience, is the company committed to compliance with employment law?" "Absolutely." He nodded confidently. "No further questions?" Ms. Hale stood slowly. "Ms. Ellis," she began calmly, "you testified that Ms. Carter did not file a formal complaint." "That is correct." "Please define formal." The witness blinked once. "A written complaint submitted through our internal reporting system. So if an employee verbally reports inappropriate conduct to HR, that would not be considered formal. It would be documented internally." "Documented," Ms. Holly repeated. "Let's talk about documentation." She approached the clerk and handed over a printed email chain. "Ms. Ellis, do you recognize this internal correspondence?" The HR director's eyes scanned the first page. Her posture stiffened almost imperceptibly. "Yes." "Is this an email from you To the Vice President of Operations, dated March 3rd? Yes, Ms. Hale's voice remained steady. Would you read the highlighted portion aloud? The courtroom was silent enough to hear the papers shift. Margaret Ellis swallowed. We have received a verbal complaint from Junior Associate Elina Carter regarding Mr. Grant's behavior. Given his position in upcoming merger negotiations, it may be best to reassign her rather than escalate. A ripple moved through the room. The judge leaned forward slightly. Ms. Haley didn't raise her voice. So Ms. Carter did report misconduct. She spoke informally. Informally? Ms. Haley repeated. And your response was to remove her from her department? It was a temporary reassignment. Temporary? Ms. Haley flipped a page. Please confirm the follow-up email dated March 18th. Margaret Ellis's lips tightened. We cannot afford disruption before the merger. Let's keep her transfer permanent and monitor performance. The words hung in the air. Ms. Haley stepped back. So when you testified that she did not file a complaint, that was technically correct, but materially misleading. Defense counsel rose quickly. Objection. Overruled. Judge Whitmore said. Ms. Haley continued. Ms. Ellis, were you aware that Ms. Carter's salary was reduced following her transfer? That adjustment aligned with the new role, which she did not request. It was organizational. Organizational? Ms. Haley echoed softly. She approached the bench with another document. Your Honor, I move to admit Exhibit 42, the company's internal performance review of Mr. Grant. The judge reviewed it briefly. Admitted. Ms. Haley turned back to the witness. Double quotes Ms. Ellis. Did you conduct performance evaluations for Mr. Grant? Yes. In this review, dated 6 months prior to Ms. Carter's complaint, is there a notation regarding boundary concerns? Margaret Ellis hesitated. Yes. And what does it state? That senior management had cautioned him regarding interpersonal conduct. So the company was aware of prior concerns. They were minor issues. Minor, Ms. Hull said quietly, then paused. She stepped closer to the jury rail, though this was a bench trial, a subtle reminder that the public was watching Ms. Ellis. Did anyone from executive leadership instruct you to handle this quietly? Silence. Defense counsel shifted uncomfortably. Ms. Haley did not repeat the question immediately. She let it sit. Finally, Margaret Ellis answered, Yes. Who? The CEO? A sharp intake of breath spread through the courtroom. Defense counsel stood again. Your Honor, sit down, Judge Whitmore said sharply. The witness will finish her answer. Ms. Hale's tone remained clinical. What exactly were you told? That escalating a harassment complaint against a senior executive during a merger would create liability exposure. And what were you instructed to do? To resolve it internally. Meaning, to transfer Ms. Carter. And if she resisted? Margaret Ellis lowered her eyes. Document performance. Concerns. The courtroom fell into stunned silence. Even the defense attorneys were no longer writing. Ms. Holly stepped back slowly. No further questions. Judge Whitmore sat very still. He removed his glasses and looked directly at Margaret Ellis. Ms. Ellis, this court is particularly concerned with corporate structures that discourage reporting. You understand that? Yes, Your Honor. You may step down. The HR director left the stand. Visibly shaken, the defense table felt smaller now. Judge Whitmore addressed the room. We will take a brief recess before closing arguments. The gavel struck. When the court reconvened, the energy had shifted entirely. The defense attorney stood first. He spoke of complexity, of corporate growth, of miscommunications. He argued that internal reassignment was standard risk management, not retaliation. He insisted that no unlawful intent had been proven, only imperfect judgment. When he finished, the room felt restrained but unconvinced. Miss Holly rose. She did not approach the bench this time. She stood beside her client. "This case," she began quietly, "is not about a recording. It is not about a merger." She let her hand rest gently on Elena Carter's shoulder. "It is about what happens when power is protected at the expense of truth." She walked toward the judge. The company had notice of prior concerns. They had a verbal complaint. They had authority to investigate. Instead, they reassigned the complainant, reduced her compensation, and documented her performance after she spoke up. She paused. "That is textbook retaliation." Her voice sharpened slightly. "And when executives instructed HR to handle this quietly, they revealed exactly what they feared: accountability. Silence. Your Honor, the defense would like this to be about procedural formality, about what constitutes a formal complaint. But the law does not require employees to navigate corporate semantics in order to be protected." She held up the email. "They chose optics over integrity." She returned to her seat. Judge Whitmore folded his hands. The courtroom waited. He spoke slowly. "This court has carefully reviewed the evidence, including internal correspondence and sworn testimony." He looked toward the defense table. "The defendant corporation argues that no formal complaint was filed. However, testimony established that a verbal complaint was made to Human Resources." He glanced at Margaret Ellis briefly. "Further, the evidence demonstrates that senior leadership instructed HR to minimize exposure rather than investigate." The judge's voice grew firmer. "An employer may not penalize an employee for reporting alleged misconduct, regardless of corporate timing." He paused deliberately. "The reassignments, salary reduction, and subsequent performance documentation occurred after the complaint." He looked directly at Mr. Grant. "The court finds that these actions were retaliatory." A wave of tension released across the room. Judge Whitmore continued. "Accordingly, this court rules in favor of the plaintiff." Elena's breath caught. The judge was not finished. "The defendant is ordered to compensate the plaintiff for lost wages, emotional distress, and reputational harm. Additionally, the court imposes punitive damages due to evidence of executive-level involvement in suppressing the complaint." The defense attorneys stiffened. "Furthermore," the judge added, "this ruling will include a directive requiring the corporation to implement independent oversight of its internal reporting procedures for a period of 3 years." The gallery murmured, but the judge raised his hand. "One final matter." He looked toward Mr. Grant. "While this is a civil proceeding, the testimony regarding prior warnings and executive concealment may warrant review by appropriate regulatory authorities." The meaning was unmistakable. Silence. The gavel struck once. Judgment entered. Elena Carter closed her eyes, not in triumph. In relief, the 12 corporate attorneys gathered their files quietly. No one spoke. Mr. Grant did not look at her as he left Ms. Holly leaned toward her client. "It wasn't easy," she whispered, "but it was right." Across the courtroom, employees from Valament Technologies who had quietly attended each day exchanged glances. Something larger than damages had occurred. A precedent had been drawn, not against success, not against power, but against silence. As the courtroom emptied, Judge Whitmore remained seated for a moment longer, reviewing the final order. The law, when applied correctly, does not shout it corrects. And on that day, it did.